Welcome back to In Session. I'm Vinny Politan. You're watching the fifth day of our coverage of Iowa versus Becker, and we're taking your calls about this case. With me here in Atlanta is In Session law enforcement contributor Mike Brooks, and in New York we've got with us criminal defense attorney Joanna Greenwald. Let's get straight to the phone lines, folks. We've got Melissa in Oklahoma City. Good morning, Melissa.
Hi.
All right, tell me, what do you think about this legal insanity defense, Melissa?
I'm appalled by what I hear in this trial. It's ridiculous for this prosecutor to say that insanity does not equal mental illness. Insanity is a legal term and mental illness is a clinical term. With the advances in science and forensic science, why has the justice system made no attempt to catch up with the advances in psychiatric medicine?
Interesting. Thanks so much for the call, Melissa. Joanna, let me go to you on this one because the prosecutor's making this statement because I think it's obvious to everyone watching this trial that this man is mentally ill, but he had to make that distinction in his opening statement to sort of set the framework for what the prosecution is going to try to prove here, is that mental illness does not necessarily equate to legal insanity. How do you see the distinction between the two?
Well, using insanity in and of itself is an affirmative defense that the defense is using. So you could have mental illness, and that's what the prosecution is trying to say, but not actually be insane at the time of the commission.
Do you think the
crime.
legal standard is fair, though? I think that's what Melissa was really getting to, was the fact that it's not fair that if someone is mentally ill, there shouldn't be a separate legal standard.
I think that because people feel, and if I'm using my defense hat, because people feel people can be mentally ill, but be able to know the difference between right and wrong, which is the standard here, and be able to appreciate the difference between right and wrong, which is the standard in Iowa for the insanity defense. That's why you don't have the merging of the two, is whether or not at the time the person could appreciate that and be mentally ill at the same time. Additionally, and I want this known, rarely do defense attorneys use the insanity defense. It's used maybe 1% of the time as a defense, and within 1% of the time, do attorneys succeed with using insanity?
Usually the only time it's successful is if the prosecution agrees that the person's legally insane. Mike Brooks, quickly, do you think it's fair? You think it's fair? Because we're watching this guy. We're watching him in the interrogation room, and it's clear that he is not like the rest of us.
No, but
what's on your mind this morning?
Okay, my concern is when Mark Becker's mother was testifying, she stated that Mark had made threats against Coach Thomas, and I'm just wondering, was there a responsibility on her part to notify Coach Thomas or the police?
That's interesting that you picked that up. Joanna, how about that? The fact that the parents or people may have known that he had made some threats or made some mention of Coach Thomas prior to the shooting. I mean, you hear that information, you know your son's mentally ill. Do you have any obligation to do anything legally?
Well, here's the problem in this case, is that in this case, the son was 24 years old. If this was a minor, they absolutely had a fiduciary duty to be very much involved, but because the child, and this is not a child, we have a 24-year-old, they may have been barred in this case of knowing just how ill this boy really was and whether or not he was taking medication and what kind of medication. So they may not have known the extent of what they were dealing with. And I just would like to point out something Mr. Brooks just was talking about as far as going forward and that there's premeditation, all these other things. Not everyone has to be the devil when someone's in a psychotic break. They could pick one person, according to the DSM-4, when you're schizophrenic and within a dissociative state, and pick one person and go straight for them and act within an irrational situation. To you, it's rational when you're going after one person. So you can be premeditated and still be psychotic at the same time. He didn't try to hide it, which actually is one of the...
All right, and you know what? That's what all these experts are going to talk about, and we've got a lot more testimony ahead.
Yes.
Folks, if you have any questions or comments about Iowa versus Baker, give us a call. Be the 13th juror and call us at 1-877-JUROR. Joanna Greenwald, what do you think happens here? I mean, does someone like Vandersloot use his situation there and somehow try to perhaps get less of a sentence through authorities in Peru and to give up information about Aruba?
Well, absolutely. I think you actually have, this is a major international situation, I see it as, because he has, as Mr. Brooks wisely suggested, in Alabama, he has a case of extortion against him there. You have an unsolved mystery in Aruba, and you have a case that he is involved with in Peru. And potentially you're looking to see if there's comedy among all of the nations to put that if he agrees to give information about Natalie Holloway to solve that crime, that potentially United States will work with him to deal with the extortion issue in order to solve the Aruban issue, since you have an American involved, and ask Peru to give some leniency. And Peru does not have the death penalty.
I know, and it seems like they can give some leniency there. Joanna Greenwald, thanks so much for joining us. Appreciate it. Mike Brooks, and of course, Gene Casares live in Lima, Peru. Thank you all.